Sir? The Judiciary Committee will come to order, and without objection, the chair is authorized to declare a recess at any time. Pursuant to notice, I now call up H.R. 2561 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2561, to amend Title 18 United States Code to permit uniformed law enforcement officers to carry agency-issued firearms in certain federal facilities and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. Today, I'm pleased to consider for markup H.R. 2561, the Protecting Officers of the Law in Civilian Establishments Act of 2017, or the Police Act. The Police Act was introduced a year ago this Saturday by Representative Trey Hollingsworth. We are all too familiar with the spate of attacks plaguing law enforcement officers across this nation. Our law enforcement officers are facing increasing levels of hostility and violence fueled by a growing anti-police sentiment. This is why we saw the Protect and Serve Act receive overwhelming support by the House yesterday. Piggybacking off of that effort, Congress should be examining ways to ensure that, if attacked, law enforcement officers have the means to defend themselves. Unfortunately, however, under existing law, uniformed state and local police officers must remove their firearms before entering federal public facilities when not responding to an emergency or acting in an official capacity. This makes them vulnerable to attack and potentially unable to adequately respond to developing situations should they arise. Just like the rest of us, law enforcement officers are often required to take care of personal business in the middle of the workday or immediately before or after their shifts. These can include medical appointments or even paperwork appointments. Regrettably, federal law requires the same police officers entrusted to protect our communities and respond during an emergency to disarm when they enter into public buildings. This places these officers in significant danger, considering that uniformed law enforcement officers already are highly visible targets to those wishing to cause harm to men and women in uniform. The solution is simple, and it is before us today. H.R. 2561 amends federal law to modify the restriction on possessing a firearm in a federal facility so the prohibition will not apply to the lawful carrying of agency-issued firearms by a uniformed law enforcement officer in certain publicly accessible federal facilities. This is a narrow, common-sense solution to a problem that puts law enforcement in dangerous situations, and I urge my colleagues to support this important measure. It's now my pleasure to recognize the ranking member of the committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, certainly we must assist our law enforcement officers who work long hours under stressful and dangerous conditions to protect all of us. However, I cannot support the bill before us today. H.R. 2561, the Police Act, would allow uniformed law enforcement officers to carry agency-issued firearms into certain federal facilities that are low security and open to the public. While there may be some merit to this proposal, there may also be risks. This committee has held no hearings about the need for this bill, and it would be unwise to move forward without a greater understanding of the potential benefits and potential dangers that may result from this legislation. I understand that the bill is intended to make it easier for police officers to conduct non-official, personal tasks, such as visiting a VA hospital or a Social Security office while in uniform. We should learn more about the problem, however, about possible ways to address it and the implications of enacting this bill as is. For instance, the bill would allow any uniformed officer from any jurisdiction to carry a loaded firearm or, quote, other dangerous weapons, unquote, into certain federal facilities. This would place an enormous burden on security guards at federal facilities who would have to recognize the uniforms of law enforcement agencies from any jurisdiction in the United States. This could also facilitate the ability of armed individuals impersonating private security guards to gain access to these facilities. Given the potential risks presented by this legislation and the lack of any documented need for it, there's no reason to rush the bill through the legislative process without the benefit of a hearing where we can consider its merits and any possible concerns or necessary changes. We should consult with law enforcement, with the General Services Administration, with gun violence prevention experts, among others, to evaluate this proposal. This bill may be well-intentioned, but it raises questions that should be addressed before the committee adopts it and reports it for floor consideration. In addition, I must note that as we once again consider legislation to loosen restrictions on gun possession, we continue to take no action to address the nationwide epidemic of gun violence. More than 35,000 Americans lose their lives to gun violence each year, while in some other countries, other major industrial countries, this figure barely cracks 100. We cannot allow this to continue. I urge the committee to hold hearings and to adopt legislation that will make us all safer without further delay. I yield back the balance of my time.
Chair thanks the gentleman. Are there any amendments to H.R. 2561? For purpose, the gentleman from Rhode Island seek recognition.
Move to strike the last word.
Gentleman's recognized for 5 minutes.
I just, I want to echo the sentiments of the ranking member. I think this is an issue which, if in fact we were attempting to address a very discrete problem of law enforcement officers not being able to access a federal building during a break, we could do that. But I'm fearful that this bill does much more than that, and I think this is one of the regrettable consequences of not having hearings where you could actually ask these questions and understand the problem that we're attempting to address in the legislation. But I'm struggling with a couple of things in terms of the language, and I'm hoping the chairman can assist, or the author of the bill or his representative. It says on page 2, the lawful carrying of agency-issued firearms and other dangerous weapons. Does that mean a non-agency issued firearm would constitute a dangerous weapon, so that you could in fact have someone who has a gun not issued by an agency? Because there's no definition that I can see of dangerous weapons. There also seems to, that's the first question. The second question, it says that on page 3, it defines uniformed officer, agent, or employee means an officer, agent, or employee wearing a clearly identifiable agency standard issued uniform with a badge. It seems as if that doesn't have a requirement in the definition that the person be, in fact, a law enforcement officer. It simply says an employee is an agent, an officer, or employee wearing a badge. And so you have some inconsistency between that definition and the definition on page 2, where it says by a uniformed officer, agent, or employee of the United States, a state, or a political subdivision thereof, who is authorized by law to engage and supervise the prevention, detection, investigation, or prosecution of any law. So there seems to be an inconsistency in the definition. And then thirdly, it seems as if this also would cover anyone involved in prevention, detection, investigation, or prosecution of a violation of law, which would seem to me to be a much larger group than law enforcement. It could involve clinical social workers, family court investigators, a whole series of people who are not who we would typically identify as law enforcement that are part of this group we're intending to address, at least in the description of the bill. So I think there are a lot of questions about its strict application here, and I think we would obviously have benefited from a hearing to get these answered, but with all of these uncertainties, it seems like it would be opening the floodgate, maybe unintentionally, to lots of people who may not even be properly trained in firearms to go into federal buildings, which I think is a dangerous precedent. Not sure why anyone would want to do that, and in the absence of some explanation for any of these questions, it's not a bill I can support. And I don't know if the chairman can respond to some of those real concerns that I have.
If the gentleman would yield.
Sure.
First of all, the language that the gentleman cites tracks the already existing federal statute, LEOSA, Law Enforcement Officers Safety Act. Secondly,
Well, just can I ask, Mr. Chairman, that may well be that it tracks it, but do you agree that there is inconsistency in the language, and the fact that it may be inartfully written at some prior time doesn't mean we ought to reaffirm it?
I don't agree that it's
So
inconsistent.
who does it apply to? Does it apply to officers who
First
are...
of all, to the first question the gentleman had, it only applies to a firearm issued by the agency, not to other not to other weapons of various kinds or even firearms that are not issued by the agency.
That's not in the bill. It says the lawful carrying of agency-issued firearms and other dangerous weapons, with no explanation of what other dangerous weapons means. So is someone who is carrying a dangerous weapon, that is a firearm that's not agency-issued, doesn't that qualify as other dangerous weapon?
If the item is not issued by the agency. It's not allowed under this bill.
Well, that may be the intention, but that's not what the language says.
I think it is the language of it. It's pretty clear. Are there any amendments to H.R. 2561?
Mr. Chairman, I'm sorry.
The gentlewoman from Texas, the ranking member of the Crime, Terrorism, Homeland Security Investigation Subcommittee, is recognized for her opening statement.
Right.
Or anything else she might want to say.
No, I was responding to having an amendment at the desk.
Oh, okay, well, the clerk will report the amendment.
Amendment to H.R. 2561 offered by Ms. Jackson Lee. Page 2, line 17, strike.
Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment. Is this the only amendment?
Well, I'm not making an opening statement.
The gentlewoman is recognized.
Mr. Chairman, I want to start by acknowledging on many occasions the collegiality in this room and with the members of this body, including Republicans and Democrats. I want to specifically take note of the work of Mr. Rutherford and Ms. Demings. We specifically voted on a bill yesterday that both of them sponsored, and I'm reminded of the emotion of which Mr. Rutherford spoke. And having been a local elected official, my interaction with law enforcement has been close and continuing. Even today, as I check on my police department, my constables, my sheriff, my rangers, we work together. We are eager to dialogue and to be of help to each other. Number two, I think it is important to know that any law enforcement certified can go into any federal building across the nation for official business and as well for any emergency. In fact, I would make the argument that they are welcomed in that instance. And I also want to acknowledge that they have utilized their profession to save lives beyond their jurisdiction. But I do think it's important that we recognize the vulnerability of uniforms being misused or other misrepresentation that may be generated by a bill that has not, to my knowledge, had any hearings before our committee. And I want to take note of the fact that it is important for this committee to be fact finders, because we have experts on the committee. We have former judges, lawyers, defense counsel, prosecutors, and certainly law enforcement, of which we're pleased. And then I would like to, if I might, I'm a little stunned in the memo that was sent out by the majority. Police agencies in the U.S. are currently facing a crisis resulting from a spate of high-profile incidences involving the use of force by police officers, many involving minority citizens. As a result, police officers are facing increasing levels of hostility and violence, fueled by this growing anti-police sentiment. In the aftermath of the August 2014 events in Ferguson, Missouri, there has been an increase in ambush-style attacks on police officers. And I would only ask and put on the record to not associate minority citizens, I'm not sure if it's African Americans or others, to take a broad brush and suggest that there is that kind of sentiment in my community. I take issue, I want it to be noted on the record that I believe the memo could have been written in a more appropriate style because there are incidences to be documented that represent people from all walks of life, and certainly my community and the minority community, with so many of us in the law enforcement agencies, take great issue with that assessment. Yes, there have been incidences, but our communities continue to try to work together. Yes, there are organizations of young people, Black Lives Matter, and their premise has not been refuted. They believe that we should assess issues dealing with young African Americans. Quickly, my amendment would alleviate the security risk posed by the bill by only allowing local law enforcement officers to carry firearms and dangerous weapons in federal facilities in the state where they serve. Under the current bill, a law enforcement officer from any state or federal jurisdiction would be authorized to enter certain low-security federal facilities carrying agency-issued firearms or dangerous weapons. This puts security personnel at federal facilities in a position of having to determine and assess someone from out of state or whether or not there's an imposter, legitimate law enforcement officer, and I would venture to say that the police people would understand that. And one can imagine a scenario in which a person who is not, in fact, a law enforcement officer puts on a police officer's uniform from an out-of-state jurisdiction and wants to bring a loaded gun into a facility. Security personnel may have difficulty visually determining whether or not someone is a legitimate law enforcement officer, with the resulting confusion leading to at least some of the imposters carrying successfully weapons past security. Let me be very clear. Officers can go into any federal building on the basis of an emergency or on official business. My amendment is intended to provide extra security not only for those in those buildings, but for law enforcement officers themselves. And so I'd ask my colleagues to support the Jackson Lee amendment and acknowledge the fact that we want to make sure that our officers are safe. And we really want to reemphasize, because that's what the police working group is about, that we're working to improve our relationships, and we are not suggesting that incidences which have occurred, and one of them occurred in the state of Texas, an ex-military person in Dallas that is alleged to may have been suffering from PTSD, as well as the individual that came in under the sovereign nation label, as I understand it, in Baton Rouge. But we want to improve police-community relations, not suggest that out of incidences that have occurred, certain minority communities may be at the core of these kinds of lack of police-community relations. I ask my colleagues to support this in the name of improved police-community relations.
The chair recognizes himself for 5 minutes. And first, the chair wants to say to the gentlewoman from Texas that he takes to heart her comments regarding the first paragraph in the memo, and would note that surely no one should suggest that these shootings are all involving minority citizens, nor would it matter if there are ambushes taking place of any kind, of anybody, by any race. We would want to make sure that added measures are taken to make sure that people are protected. And I also agree and share with her concern that other things can be done besides additional protections for law enforcement officers to try to improve that situation so that the number of those incidents are reduced. However, the amendment before us today does not take into account the realities of modern-day commuting or work habits. Take the region around us right here as an example. We have workers that come from Maryland, Virginia, Washington, D.C., and some as far away as West Virginia or Pennsylvania. I'm not comfortable telling those who work across state lines or those who might need to travel across state lines to visit a VA facility that they cannot defend themselves. In my own district, particularly at the northern end of it, many residents travel to the closest VA facility, which is in Martinsburg, West Virginia. Law enforcement officers in uniform who make that trip are no less a target when they travel across state lines than when they remain within Virginia. Further, LEOSA already allows these law enforcement officers to travel across state lines with their firearms. There's no reason to treat them differently than those law enforcement officers in the state where the federal facility is located. Finally, the VA as a federal agency is organized by geographic regions, not states. A uniformed law enforcement officer of one state's police department should be allowed to head across the border, complete a physical, pick up a prescription, and be back at work all in a lunch hour. It is for these reasons that I must oppose the amendment. I urge my colleagues to do the same, and I would note that the underlying bill is supported by a wide array of law enforcement officers, including the National Association of Police Organizations, and therefore the issue of determining whether or not one is a legitimate police officer or somebody posing as one is certainly a concern, but one I think that the law enforcement organizations and the federal facilities that they're protecting should be prepared to address. So for those reasons, I must oppose the gentleman's amendment.
Would Chairman yield?
I'd be happy to yield.
Over to your right, Mr. Chairman. Thank you, Mr. Chairman. I just want to put a short point in that I didn't hear in anybody else's dialogue, excuse me, and that is that under current law or under the gentlelady's amendment, what will happen in practical application is the officers are likely to leave their weapons in their car and lock the car up and get out. And I'm going to suggest that they're safer on the officer than they are in the car, subject to potential theft, which would be more mischief than you might have with an officer that's duly licensed and trained to carry that weapon. I want to add that point to this and yield back to Chairman.
Reclaim my time. The gentleman makes a very good point. There have been instances where weapons have been stolen out of vehicles and used for unlawful purposes, and people have been harmed as a result of that. I also would ask unanimous consent to place in the record a letter from the National Association of Police Organizations supporting the legislation. Without objection, it will be made. Mr. Gentleman from Tennessee, seek recognition.
Strike the last word.
Gentleman's recognized for 5 minutes.
Would the chair yield? I missed a little bit of your
got the time.
Your opening statement, and can you tell me the situation, the incident that provoked this bill, where somebody went into a federal facility and either their gun was stolen at the federal facility in the parking lot, or the officer was endangered at the federal facility and needed a gun to protect himself? Yeah, I do yield, please. Thank you.
What I say would only be hearsay because it's not my bill. It's introduced by the gentleman, Mr. Hollingsworth, who I believe is from Indiana, and he was contacted by law enforcement officers in his district requesting that he undertake this. I think that's the genesis of this.
But is there any example of this being, that we know of, that somebody...
I don't have one that I can offer for you right now.
All right. I suspect, sir, that there isn't an example that somebody has gone into a VA and been shot or attacked, and they didn't have a gun to stop a bad guy with a gun. And I'm just concerned about us telling folks who might have PTSD going in to visit their psychiatrist that they're taking a gun, and one day this could cause more of a problem than we think we're solving, because there's no example of a situation where this has caused an officer to lose their life. This is supposed to be protecting police, but we don't have a situation where police have ever had a gun stolen on a federal facility when they locked it in their car, or an example of some place where somebody's been attacked and they didn't have a gun to protect themselves and weren't as capable as James Shaw in being able to defend themselves without a gun. So I don't know why we're doing this. Mr. Chair, if you yield, what's the definition of a level 1 and level 2 federal civilian federal facility?
Generally, it is open to the public, and low security is a level 1 facility.
So would this permit people to take weapons into the federal office buildings where many of us have our offices?
Yes. Well, it depends on where your office is located.
Well,
If it's a United States courthouse, it would not. If it is if it's shared with other federal agencies that are not in a courthouse, like a VA building or something like that, then yes.
so a federal courthouse is not a level 1 or level 2 building? Is that for sure? It's not?
Yes, I am so informed.
Okay. Well, we have no example of anybody at the VA who needed this help.
Does the gentleman yield back? Gentleman yields back. For what purpose does the gentlewoman?
No, I don't yield my time back. I
Okay,
yield to
well-
you to respond.
I don't have any further response.
All right, so the bottom line is this is some hypothetical thing, and you say the police would like this and all their, sure, the police would like to have their guns everywhere. And that doesn't mean we let them have guns everywhere. They should have them when they're on patrol and when they're working and when they're in their jurisdiction or whatever their state controls and determines they should have their guns. But, you know, I don't know that, this looks like, really looks like a show business. And meanwhile, we're having, you know, the Senate Intelligence Committee says that Russia interfered with our relations and our elections and preferred Trump, and basically saying the House didn't do their job, and our Intelligence Committee that closed their investigation, and we're talking about a hypothetical about somebody carrying a gun into a VA facility. I mean, this is misplaced priorities. The Republic is on fire. And some of the things we've been seeing and learning from media reports should cause this committee concern to have a hearing on some of these issues that the Intelligence Committee in the House failed and that didn't live up to their duties to be a check and balance as the Senate Intelligence Committee did. And Senator Burr made clear that he believes that the Russians favored Trump and that the report is totally accurate. And we see so much about Russians and money and the young Trump who doesn't know if his father has a blocked call phone or not. I mean, young Trump is like a cat that goes out and gets a chipmunk. They bring it back to their owner. Young Trump would have told the owner what went on. Yield back.
The time of the gentleman has expired. For what purpose does the gentlewoman from Florida seek recognition?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you so much, Mr. Chairman. As you all know, we just recognized law enforcement officers from all over the country, particularly those who lost their lives in the performance of their duties last year. I wore the uniform for 27 years, and I was subject to the same restrictions that we are talking about today. And I am sensitive, of course, based on my direct knowledge and experience, to the challenges of officers who may need to take care of personal business while, quote, on duty. But I do believe, and I am concerned, that allowing any law enforcement officer from any agency from within the country to carry firearms in any federal facility, I do believe that it puts an undue burden on security in those in those buildings to verify the credentials that those officers have. I think we want to get this right. We have to get it right. I'm not sure. I know it's Police Week, which I'm very much in tune with that. But I do believe we should take the time, have hearings on the matter, hear from those who are directly impacted, adversely impacted, as opposed to pushing the legislation through today. And with that, I yield back.
Would the gentlelady yield? Would the gentlelady yield?
Yes.
Thank you. Let me thank you for your comments, and as I started out, I indicated that there were no hearings, but I think you have raised a very important point about getting the facts and understanding the facts. I'd like to encourage my colleagues in the interim to support at least a small limitation, which could then be more efficiently regulated, is to, if this is to go forward, to allow it to the states. But the idea of us being fact finders, as you have indicated, to do what is right for all of our constituents, and law enforcement are constituents of the Judiciary Committee, and I'm proud of that. And so I'd ask my colleagues to consider it, and I'm very grateful for the thoughtful comments that the Congresswoman has just made. With that, I yield. I thank you for yielding.
Would the gentleman yield?
I yield.
Would you yield for a question? I'm also impressed by your statement, having been a law enforcement officer for a few decades, is I'm reading this bill, and again, I'm laboring under the same disability you are, which is we've had no hearing on it, so it's unclear exactly what it means. But part of it says the term uniformed officer, agent, or employee means an officer, agent, or employee wearing a clearly identifiable agency standard-issued uniform with a clearly identifiable agency-issued ID badge. Would your reading, I mean, if you were a law enforcement officer and you were looking at that, would you think that you have to admit not just officers, but other employees? They might be postal employees or firefighters or someone who's got some kind of uniform and a badge on.
I would definitely interpret it in that way. I think you would need to verify or limit it to sworn law enforcement officers as defined by law.
Would you think that it should be sworn law enforcement officers just from the state? If the justification for this bill and its provenance does seem mysterious, but if the justification is that it's for the convenience of the officers to be able to keep their firearms on them, should it just be officers, sworn law enforcement officers from the state itself, so it's not someone traveling from across America who's not subject to the laws and the regulations of law enforcement authorities within the state?
And I do think we have to consider, and that's why I think the hearings would be beneficial. Officers could be off-duty performing a personal matter and an emergency arises at that time. So it's very possible that they could be on unofficial business, but then need to be pressed into service. I understand that without a doubt. But I do think limiting it to a state as opposed to in its current form would at least, I think, make the credentials more recognizable and they would be more familiar within the state that issued them.
Thanks. I yield back to you.
Mr. Chairman,
This gentleman from Rhode Island, seek recognition.
move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I rise in strong support of the Jackson-Lee Amendment. The most compelling testimony that we've heard on this bill just came from Chief Demings, and I thank her for that. I think we all, every time we approach legislation, want to balance certain interests, and it seems to me this amendment does a very good job of striking the right balance. If, in fact, the argument for this legislation is that police officers who are occasionally have to do personal errands or run into go to a federal building while they're on duty in uniform, that this is a terrible inconvenience, and one assumes that's the case, then the Jackson-Lee Amendment would strike the right balance and say, okay, the vast majority of those circumstances will be people who are running errands in their own jurisdiction. It seems odd that someone would put on their police uniform to go to a pharmacy in another state. So I think it would cover most cases. Of course, we don't know that because we don't actually know that this is the real reason for doing it. We don't actually know whether it's actually a problem because we haven't had a hearing. But assuming that that claim is the reason this bill was put forth, I think the Jackson-Lee Amendment strikes the right balance because the danger that someone will be wearing a police uniform from another jurisdiction, purporting to be a police officer from another jurisdiction, when the person required to check that may not be familiar with uniforms outside their jurisdiction, imposes some danger. And so let's remediate that, reduce that likelihood, and focus it on what will actually address the purported problem, which is exactly what the Jackson-Lee Amendment does. It balances, I think, in the right way, and I think it makes sense. We don't want to inadvertently create greater danger for police officers in an earnest attempt to do something to accommodate an issue that has been raised to the sponsor of the bill. So I thank the Congresswoman from Texas for this very thoughtful amendment that I think strikes the right balance that will, in fact, accomplish a very important objective in the bill. And with that, I yield to the gentleman from Maryland.
Thank you so much for yielding. But I think if we're going to move forward with this legislation, we absolutely need to have the Sheila Jackson-Lee Amendment on it. Again, we haven't had a hearing, so we don't really know what the factual predicate is for changing the law in this way. It has been suggested that the sponsor believes that it will make life more convenient for officers who don't want to remove their weapons and stop off in a federal building to do some business. If that's the case, surely it should be confined and limited to people who are sworn law enforcement officers, or at least sworn law enforcement officers and employees, which I guess is imported through this amendment, who are from the state itself. Because there is the problem of imposters. We are opening up a huge loophole here, And the minute that the word goes out that all you've got to do is put on something that looks like standard issue uniform and you can get in to a federal building with a weapon, that will certainly be a principal mode of attempting to get into federal buildings to conduct mischief, and it's far more likely that that's going to happen from someone crossing the country than someone who's within the state itself. So I think the amendment begins to tighten up, which is a very loose and porous piece of legislation. I yield back.
Thank you. I just want to add before I yield back to the chairman, the gentleman from Iowa mentioned this notion about, if you didn't get to bring it into the building, you would have to lock it in your car and someone could steal from your car. Again, it'd be really useful to have hearings when we could determine how often that happens, what kind of risk it is. My experience is that many federal buildings have secure lock facilities that when you go in, they secure your firearm before you go into the building. It would be nice to know in these level 1, level 2, level 3, how many of these federal buildings have locked facilities for firearms, how many don't, how real is this risk that it will be left in a car and stolen. I mean, this is what the American people expect us to do, to have hearings, to listen to evidence, to determine how do we develop good public policy based on that those sets of facts and the kind of circumstances. This is the danger of sort of pulling a bill, having no hearing, throwing it on for a markup, and just sort of hoping the emotion of our love for police will compel us to pass a bill that's poorly written, that may endanger police officers, and that may be completely unnecessary because it's National Police Week.
Gentlemen, would the gentleman yield for
I'd be
just
happy to yield.
one moment? It will only be a moment because it struck me, for those of us, a number of us are lawyers on the committee, and we're in and out of federal courts, and I just had a moment of being of great concern for federal courts for imposters, because who knows of someone that may have a particular angst against a decision made in a federal court and against a judge. With that, I yield back. I thank the gentleman for yielding. And ask my colleagues to support the amendment.
I thank the gentleman. I yield back, Mr. Chairman.
Yeah, I thank the gentlewoman for her comment. The bill does specifically exclude federal courts. The question occurs on the amendment offered by the gentlewoman from Texas. All those in favor respond by saying aye. Aye. Those opposed, no. The chair, the noes have it. A recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. King? Mr. King votes no. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Rutherford? Ms. Handel? Ms. Handel votes no. Mr. Rothfuss? Mr. Nadler? Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye. Ms. Demings? Ms. Demings votes aye.
Gentleman from Texas, Mr. Ratcliffe.
No.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 9 members voted aye, 12 members voted no.
And the amendment is not agreed to. Are there further amendments to H.R. 2561? For purposes, the gentleman from Rhode Island seek recognition.
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 2561 offered by Mr. Cicilline. Strike and
Without
other.
objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. My amendment simply strikes the three words "and other dangerous weapons" on page 2, lines 13. As I mentioned in my opening, I'm concerned that the bill authorizes the lawful carrying of an agency-issued firearm, which is a very discrete set of things, agency-issued firearm, but then says "and other dangerous weapons," with no definition of what those other dangerous weapons could be, or even any qualifier that be an agency-issued dangerous weapon. So we ought to at least eliminate that someone who is potentially an imposter can bring in something which is not a firearm that can cause significant injury to others. And it also is, if it's the case that we're saying police officers need to have their firearms to defend themselves, it's hard to imagine that this other category would be necessary if they have their firearms. So I don't know what it means. It seems to be a huge hole in this bill that would allow the carrying of dangerous weapons undefined, not issued by an agency, by definition, not defined in the statute or qualified by agency issued, into jurisdictions in which the person is not a police officer or law enforcement officer, which I think presents enormous potential for mischief and danger, and I think it's unnecessary, and I urge my colleagues to support the amendment.
The chair recognizes himself in opposition to the amendment. Dangerous weapons is a term that is defined in the underlying statute at 18 U.S.C. section 926. 930, subsection G2. The term dangerous weapons means a weapon, device, instrument, material, or substance, animate or inanimate, that is used for or is readily capable of causing death or serious bodily injury, except that such term does not include a pocket knife with a blade of less than 2.5 inches in length. And I would just add to that law enforcement officers carry a variety of defensive weapons that are issued by their departments. They can include nightsticks, tasers, flashlights, pepper spray, and other similar items. These items are routinely issued to law enforcement officers, and further, they receive training on how to use these items. And I would note that in most of these instances, these items are less dangerous than firearms, and therefore it makes no sense to me to tell them they can't bring those items into these
Would the
public
chairman yield to a
buildings.
question?
I'd be happy to yield to the gentleman.
Would the chairman, I withdraw my amendment if the chairman would agree to a friendly amendment to add agency issued before dangerous weapons.
The chair would accept that. I don't think it's necessary, but I would agree to that. Makes it clear that the words agency issued applies to both firearms and dangerous weapons. Before, does the gentleman from Colorado have a concern?
I do. Oftentimes in rural agencies, officers buy their own and bring their own weapons to the department that they are working for. So that would not be an agency-issued weapon.
Well, but the statute already provides for agency-issued weapons, but then it says other dangerous weapons, and I think the solution to your problem would simply be that they would have the agency authorize the weapon even if the individual purchased it.
Oh, you're saying, so the agency would authorize a weapon that the individual would purchase then?
Correct.
Okay.
Correct.
Would the gentleman yield?
Who's seeking? I'd be happy to yield to the gentleman.
I think a way to handle that concern, I certainly understand it, would be agency issued or agency approved.
Okay. If the gentleman from Rhode Island is okay with that, we are considering an amendment that has not yet been placed in writing, but it would read after or immediately before dangerous weapons, add the phrase agency issued or agency approved.
That's acceptable, Mr. Chairman.
Right. What purpose, the gentleman from Iowa seek recognition?
Mr. Chairman, I just think that this has been turned into a far more complicated issue than it is. I mean, we have law enforcement officers that are entrusted with enforcing nearly every aspect of the law that I can think of. And we want to train them, we want to equip them, we want them to have the best amount of self-defense they can have. We want them to use that at the appropriate trained times. And we're down here slicing and dicing and splitting hairs about whether an officer can fire up his lathe in his basement and turn out his own billy club and bring it along or not without getting the permission of the department. I just think we've gone way deep into the rabbit trail here, and if we're going to give them the authority to move across state lines and into federal buildings, we ought to decide to do it. And I think the underlying bill is written clearly and accurately. And I want to just get on to the final passage of this bill. So I oppose this amendment, and I actually also oppose the negotiated components of the amendment. Let's get to the base bill and pass it, because we owe it to our law enforcement officers not to complicate their lives anymore.
Would the gentleman yield?
I'd be happy to yield.
I share the gentleman's concern. However, since we've already used the phrase agency-issued firearms, I have absolutely no problem applying that. And as Chief Demings has suggested, the term agency-issued or agency-approved prior to the term dangerous weapons, which are defined in the federal statute.
And in reclaiming my time, I do disagree, because there's such a variety of weapons, and the officers some of them are required to equip themselves, as Mr. Buck said, and the whole variety of that. The solution that the gentlelady from Texas offered seems to be a reasonable solution to me, but on the other hand, it's just too much burden for our officers.
First of all, I think some members on both sides of the aisle would say that there's a semantics issue here in terms of whether or not the first use of the term agency issued modifies both firearms and other dangerous weapons, or whether it's not. And I think all we're trying to do here is clarify that it modifies both. So I agree with you that we're making a lot out of a little, but if it helps, I think it doesn't hurt in terms of the clarity of the section to make the change that the gentleman from Rhode Island has offered, modified by the gentlewoman from Florida.
Reclaiming my time, I maintain my position, but I yield back to the chair.
What purpose does the gentleman from Arizona seek recognition?
Move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. If we're going to make that modification when we're talking about other weapons, other dangerous weapons, we probably need to make the modification on line 12 of page 2, the lawful carrying of agency-issued or agency-approved firearms.
And if the gentleman from Rhode Island has no objection to that, I would consider that a friendly amendment to the amendment.
I defer to the Congresswoman from Florida as to whether or not that's appropriate. I don't know enough about, again, what's agency approved versus agency issued. Approved is fine.
The question occurs on the amendment offered by the gentleman from Rhode Island. All those in favor respond by saying aye. Aye. Those opposed, no. Being the chair, the ayes have it, and the amendment is agreed to. The previous amendment is withdrawn. The previous amendment offered by the gentleman from Rhode Island. Are there further amendments to H.R. 2561?
Mr. Chair,
Who seeks recognition?
move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you very much. Again, in lieu of an actual hearing where we could explore the dimensions and the implications of this legislation, I was hoping that perhaps you, Mr. Chair, or another member could just answer a couple questions about the intent and the scope of this legislation. As I understand it, this would apply to employees of states and political subdivisions, as well as of the United States. Is that right?
That's correct.
Okay, and if the chair would yield for a further question, do those people have to be sworn law enforcement officers? Could someone be, for example, a state agricultural inspection officer? Could they be a meter enforcer for the Chicago Police Department? Because it says employee, and so
If the gentleman would yield, I think that is defined by lines 17 through 19, who is authorized by law to engage in or supervise the prevention, detection, investigation, or prosecution of any violation of law.
right. So if I'm a meter enforcer in the city of Chicago, I'm interested in preventing, detecting, and investigating people who are, not conforming to the parking laws.
If you are a meter enforcer in Chicago who is authorized to carry a firearm, then the answer would be yes.
Okay, and the same with an agricultural inspector, if they're
If they're authorized by their agency to carry a firearm, the answer would be yes.
right, if their gun now is either issued by or approved by the state or local. Okay, again, in lieu of a hearing, do you know how many public employees at the local, state, and federal level would be swept into the new expansion of this
That I do not.
exception to the law? I mean, yes,
Would the gentleman yield?
please.
Typically in law enforcement, we have sworn officers and non-sworn officers. And so a sworn officer is someone that has the training to carry a firearm, make arrests, and go forward in that manner. And this is intended to cover sworn officers, not non-sworn or civilian employees. So authorized by law is the term that's being used to cover sworn officers.
Thank you. Would you be amenable to just making that explicit in the way we just made?
I think it is explicit by saying authorized by law. In law, you have a distinction between sworn and civilian.
Well, are you telling me that there are no unsworn employees who have the right to carry weapons or arms?
I'm telling you that's the case in Colorado. I don't know about the other states. I do know in Colorado that's the case.
Would
Well,
the gentleman from Maryland yield?
By all means.
Just a point of clarification for me, the bill talks about uniform officers with a clearly identifiable agency standard issued uniform, which would not include detectives or those sworn members who don't wear a uniform to work every day, but would still have the same challenges as the uniform officers. Are we excluding the detectives or plainclothes, undercover officers, detectives? They wear no uniform. Would they be excluded in this bill?
If the gentlelady would yield back, and that's the perfect kind of question that we'd be able to raise at a hearing if we were serious about coming up with something that would actually benefit law enforcement personnel. So that's another question to put on the table. It might be over-inclusive in that it includes the meter inspectors and agricultural inspectors, but it might be under-inclusive with respect to actual law enforcement officers who are detectives who are plainclothes. What could we do about that problem?
The gentleman would have to repeat his question. If it's directed to me, I was conferring.
Yeah, no, I was essentially just channeling the question of the former police chief of Orlando, Florida, who's saying, would this not apply to the tens of thousands of detectives across the country who are plainclothes, who are not wearing a uniform?
It does not apply to them.
Okay.
But if you want to offer an amendment to make it apply to them.
Well, I would
sure
love to have a
there'd be members on
hearing
our
so we
side
can
of the aisle who
explore
would
all of these issues. You see, I mean, what we're trying to do is to smuggle a hearing into a markup session, and some people are even impatient with having a markup session. But, you know, it just seems like this is a travesty of the legislative process. But, you know, we've passed several bills on a bipartisan basis that I know the law enforcement community is interested in, and we're able to do that when we actually come together and have a hearing and answer all the questions. But here, we don't really know what the implications of this bill are. So I would move that we have a hearing on it and then proceed. I'm happy to yield back.
Mr. Chairman?
For purpose, the gentleman from Florida seek recognition.
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, I appreciate the attention that the committee is giving to improving safety for our law enforcement officers who put their lives on the line to keep our community safe every day. What I don't understand is why we could not, as we've already heard, have spared just a little more attention to this bill, why we couldn't have had a hearing to learn more about the problem. I have heard from officers in my district who are concerned that being forced to leave their firearms locked in their vehicle just makes their vehicles targets for savvy criminals who understand that a marked car is likely to have a gun inside. We all want to prevent the cowardly targeting of law enforcement, especially as they seek medical care in the VA or go about other important personal responsibilities, but I genuinely don't understand much about this problem. Is it a reasonable solution to check firearms at security checkpoints, after which presumably the building is secure? Does that solve the problem without having officers carry firearms throughout a building? I honestly don't know the answer to that, and I'm not convinced that it's reasonable to solve a problem that I, and as we've seen, other members of this committee don't fully understand. I'd also love for this committee to examine other ways to protect law enforcement officers in our communities, like the Jake Laird Act that Representative Brooks and I recently introduced,
That's a bill named after a police officer killed in the line of duty by an individual with a history of mental illness who never should have had access to firearms. And I hope the committee can give some attention to this issue in the near future so that other officers don't have to face preventable dangers in addition to the many real dangers that they face as they do so much to keep our communities safe. But I also want to raise, Mr. Chairman, an unrelated issue that is within our committee's jurisdiction. The New Yorker reported that a law enforcement official believes that suspicious activity reports related to the transactions by Michael Cohen, President Trump's personal attorney, are missing from the Treasury Department's Financial Crimes Enforcement Network database. And I would like to submit for the record this article entitled "Missing Files Motivated the Leak of Michael Cohen's Financial Records." I'd like to submit that for the record.
Without objection, that will be made a part of the record.
Thank you. There is a lot that we don't know about this story, but the article, I need that for a second. The article, thank you, indicates that searches of the database failed to return 2 previous suspicious activity reports referenced in a 3rd suspicious activity report filed by First Republic Bank related to Michael Cohen's account for Essential Consultants. The details of this first and 2nd suspicious activity reports are unknown, but their absence from the FinCEN database is a matter that is rightly within the jurisdiction of this committee. This committee must examine both Treasury Department and Justice Department policies and procedures related to the retention of and access to suspicious activity reports to ensure that law enforcement officials are able to conduct their work without interference. That's the reason, Mr. Chairman, that I'm making this request for a committee hearing on the policies and procedures regarding the retention and access to these records so that law enforcement can do its job. And, Mr. Chairman, we should give Secretary Mnuchin the opportunity to testify under oath, whether in public or a closed session, in order to understand why 7 former government officials and other experts familiar with the Treasury Department's FinCEN database expressed varying levels of concern about the missing reports. We have an obligation, Mr. Chairman, to do our job, and we must understand what is happening here, and we can do it by simply doing the work that our constituents expect us to be doing in this committee, and that is conducting the necessary oversight that we ought to be engaged in. And I will submit this letter to you and hope very much that we're able to have that important hearing and that we're able to schedule it soon. And I yield back.
Question occurs on final passage of the bill. A reporting quorum being present, the question is on the motion to report the bill H.R. 2561 as amended favorably to the House. Those in favor will say aye. Aye. Those opposed, no. Ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. This concludes our business for today, and thanks to all our members for attending. The markup is adjourned.